And the attorneys for both sides said, well, not very much. The state will not be able to collect fees for uh, piers on the river, on the lake bed, on the lakefront, where they encroach on the bed. And the tribe will be able to take those fees. But other than that, there's no direct costs involved. Well, that was true, but what nobody was mentioning was that there's a hydroelectric dam at the outlet of Lake Coeur, owned by Avista, the former Washington Water Power Company. And of course, once this lawsuit was settled, a second lawsuit against Avista was begun because the tribe then claimed that half of the power, or a large portion of the power that had been the revenue that had come from the dam over many years had come from water that was in the portion of the lake that belonged to the tribe. So there was really a fair amount of money involved in that one. And I did testify on that one. I didn't change my testimony, although the tribe offered alternative testimony claiming claiming to own the whole lake. But they were happy with the settlement, which I think was $250 million. So that's pretty much the story of the Coeur d'Alene case. There are, as it turns out, there aren't a whole lot of expert witnesses in history who deal with submerged lands and the equal footing doctrine. And so I immediately began getting requests from other tribes to deal with similar cases that they had going. The next case I did was with the Hualapai. The Hualapai are in the west end of the Grand Canyon. And when their reservation was established, it's a complicated deal. Eventually, it was also an executive order ratified by Congress. And the boundary was placed down the middle of the Colorado River. So theoretically, the tribe owned to the middle of the Colorado River all along its reservation boundary. And they were well aware of that, and the United States was well aware of it. The United States, the National Park Service, however, claimed it was not aware of this. And anybody who's been down in Colorado will know that you normally get out at a place called Diamond Creek, which is on the reservation. It's the only, you have to, if you don't get out there, you've pretty much got to go to all the way to the dam. And so the Park Service tried to prohibit the tribe from having that pier there, that little pier, which was about their only source of income. So I submitted a report in which I showed what the law was, or what the history of the legal application of the law was. And eventually the Park Service relented and agreed that the tribe did own to the middle of the river. I'm going to stop and just tell a little interesting story that goes along with this. The Hualapai tribe are very remote. You know, the Grand Canyon is a pretty remote place. The West End is even more remote than the Park Service portion. When I got done with this report, the tribal council said, well, we have another question for you. We think that when our reservation was established, the western boundary was supposed to be 10 miles further west than it is currently acknowledged by the United States. And we'd like you to research that. And I said, well, gee, you know, it was established 150 years ago. I kind of doubt the evidence is going to be around. And I don't want you to waste your money. But they said, we want you to look every place you can possibly look. So I did. And I found that it was interesting. I found survey notes that described where some markers had been set in the 1930s by an investigator for the Interior Department. And then I remembered that there was a map in the that was located in what was called the Phoenix Area Office of the BIA at that time. And if you put the two things together, they finally made sense. If you just looked at the map, you couldn't even tell what state it was in. If you just look at the field notes, You couldn't tell what state it was in either, but he put them together and it became very clear that it was actually a map of the western boundary of the Hualapai Reservation. And it turned out that a fairly famous attorney had been hired by the Interior Department in the 30s to go out there and see if this story was true. And he did, and he hired a surveyor to go out and map the markers that had been set by the military in the 1870s. And the surveyor marked two or three of the cairns in his maps, and then a number of white ranchers came out with loaded guns and told him they'd shoot him if he kept on surveying, so he quit. And so I told the tribe about that. I said, you know, they're pretty remote. You have any way you can loan me a helicopter for a day? And so they gave me a helicopter for a day, and we went out there. And right on the military officer who had been putting up these pylons had been aware that in the future there might be dispute, and so he put them in very remote locations. And the first two were on high buttes, and it was very windy. It was a pretty difficult landing for the helicopter, but we found the first two. And then he said, the pilot asked me what I wanted to do. And I said, well, can you take a reading due north from this last one? Because that's where the next marker should be, right on the edge of the Grand Canyon. So he flew due north using his GPS system. And we got to the edge of the Grand Canyon. And there, on the way, I said, wouldn't it be great if they signed this one? And right when we got to the edge of the Grand Canyon, there was a big pile of rock, and next to it, in using stones, big stones about maybe this big around, was the word U.S. Army spelled out on the ground. Couldn't see, it was pretty hard to see from the ground, but you could see it from the air pretty clearly. And so the tribe, I told the tribe, well, you probably can't recover any money for this. It's just been too long. And they said they didn't care. It was just getting their elders' traditions confirmed was the most important thing to them. So that's Hualapai. The third one is a little closer to home. And in about, I think it was about 1990, about 30 years ago, I had an office down by Pioneer Square in Seattle. And the chairman of the Colville tribes and their attorney came in, and they said they'd heard about the Coeur d'Alene case, and they wondered if I would look at a similar case that they have. And I said, well, I'd look at it, sure. And it took about 15, 20 years, but eventually we dealt with the issue over Wells Dam. And what happened with Wells Dam was the Douglas County PUD constructed the dam, and they constructed it on Indian land that had been allotted to tribal members. And in order to do that, they pulled a sneaky deal with the Chelan County PUD, and they told the Indian owners of the property that the property was being condemned to the dam. Well, this was untrue, and they, fortunately for me, for the tribe, they kept notes of this meeting, which they probably wouldn't do today. And they were housed in an archive about 6 or 7 stories down in the Wells Dam, which was a pretty interesting place to do research. But I found those notes, and eventually the tribe argued that because the boundary of the Colville Reservation is down the middle of the Columbia River and the Okanagan River, that much of the reservoir that is being held by the dam is on Indian land, and therefore the tribe was owned a percentage of the proceeds, the net proceeds annually from production of hydroelectric power. And once the PUD had agreed that the tribes did own the land, then the whole question was how much were they owed. The the tribe had wanted back payments, but one of the things I learned, well, I didn't really have anything I sat in the rest of the meetings, but I didn't have anything to do with the decision on how much money was paid. The, one of the things that I learned was that the PUDs, they have money coming in every year and it all goes out every year. So they don't really have a big bank account. They had no means whatsoever to pay a back payment. So the only way that it could be negotiated, which the tribe argued that they had to have as large a possible payment through the future years as could be made. And the PUD agreed eventually, and they now have a payment that is due each year uh, for the proceeds, a portion of the proceeds from the dam for the rest of the current FERC cycle for the Federal Energy Regulatory Commission, which gives a 50-year license for dams. So they're getting a payment for the remainder of the years in the current license. It may be up now, and then another 50 years from from the point of when the last one was up. So it ended up, if you add all that up, it's several $100 million. I don't know how much. So those are three cases that deal with submerged lands, the equal footing doctrine, and the reservation of navigable bodies of water by the federal government. So I wanted to leave some time for questions. Are there any questions?
I'd be interested to know your views on as this region tries to deal with water rights and use rights and just the future of things around here. How will the Colville tribe fit into that?
Well, the Colville tribes, there are 12 tribes. One of those 12 is the Methow, which of course came from this watershed and basically occupied the land and most of the watershed, a little bit of the upper northeast section of the watershed was occupied by Okanagans. But the Methow have made it pretty clear that they have the same objectives that non-Indian residents of the valley have. They would like to see remain as green as possible. They'd like to see the least amount of development possible. They prefer to see agriculture. They're very much committed to salmon recovery. They have a slightly different view from the Yakima. Most of the construction projects that you see in the valley are Indian construction projects for salmon recovery are by the Yakima tribe. They're a treaty tribe and they have money from, as a result, they have money from the BPA, the Bonneville Power Administration, which has to be used each year for salmon recovery. The difference in philosophy, the main one that interests me is that the Yakima, like the BPA, and the BPA is constrained by law. So it's not, they don't, the BPA and the Yakima don't have any real choice in what they do. But they think everything they spend money on has to increase the number of salmon that come back and spawn each year. So sometimes you can see several $1,000,000 spent on a tributary where you may only get a handful of more fish going up the tributary as a result. The Colville would like to see more money on projects that protect existing spawning areas. Now, this doesn't fit in with what the courts have demanded from the BPA because there's no metric to show increased salmon recovery. So the tribe has at times spent its own money to try and protect areas that they see as being proper spawning areas that and buying those areas and just protecting them from development. So I would say that that I'm unaware of any cross purposes between the Methow and therefore the Colville tribes and the non-Indian residents of the valley, at least those that don't favor heavy development.